Welcome, everyone. I'm Mimi Paxson, Associate Director of Business Development at Polunsky Beitel. Today, we have Ty McWhorter as our special guest. He's an Associate Attorney with Polunsky Beitel in our Dallas office. Every month, we publish a Mortgage Law Minute, which contains valuable information about the mortgage industry. In this month's Mortgage Law Minute, Ty addresses the latest amendment to Freddie Mac's selling guide on powers of attorney. Ty, could you give us an overview of the most recent reform?
Oh, yeah, certainly, Mimi. And thanks for having me. Really appreciate it. It's nice to be here. But I think right before I get into kind of like the nitty gritty of this, it's nice to have a little bit of context on what exactly has kind of happened in the interim here. Freddie Mac initially announced much more drastic changes to their POA requirements in December of last year. After that, they then issued kind of a clarification, but they did walk some of those kind of restrictions back, and that was announced in February. And then most recently, March 3rd, they announced really just an extension of the mandatory implementation date for these changes, so that the new start date is going to be for applications received on or after June 30th, 2021. So really kind of the main takeaway here is that the changes, and the changes that we'll discuss today, were actually announced in February, but they do not take effect until June 30th, essentially.
Gotcha.
But from those changes, there are two pretty significant ones that I want to delve right into. Number one being that Freddie Mac has limited the circumstances where a POA may be used to a medical emergency or a natural disaster or a hardship, but that hardship needs to be a situation where the principal is unable, or principal or borrower is unable to attend closing or even sign the documents electronically, which is kind of more of a shift than what we're used to with Freddie Mac. They also kind of reiterate that point by stating that it cannot be for the mere convenience of the borrower. So they're really, reiterating that it needs to actually be a very unique and emergency circumstance, essentially. Or it's a situation where the applicable law, usually the state law, requires that the POA be accepted. Number two is that Freddie Mac will allow an individual to appoint, their family or member or their, personal attorney, but the one that everyone was used to that's now been taken away is the personal relationship. And while Freddie doesn't actually define, a personal relationship, I think everyone's kind of used to people appointing a very close friend to serve as their attorney in fact or agent to sign on their behalf. And Freddie has made that clear now that that's no longer the case. It needs to be a family member or personal attorney. That said, they did add adopt the flexibilities that they announced in March of last year, kind of in response to COVID. And one of those flexibilities that they've adopted is that an employee of the title company may serve as the attorney in fact, so long as that closing protection letter is issued by the title insurer, which is, I think a lot of people at this point are pretty used to that requirement or caveat of flexibility from March of last year. The other big adoption that they have of the flexibilities from last year is that they now require this, but this was for all POAs and not just the purchase transactions like it used to be, is that they'll require a discussion with the borrower from either the employee of the lender or employee of the title company, explaining the terms of the loan, and then that needs to be kind of memorialized in acknowledgement. And that acknowledgement can be in any form. It's because at least Freddie hasn't specified exactly what form, so it's kind of our opinion that it can be like a signed document from the borrowers, or it can be an email kind of stating that the borrower received a CD or a settlement statement, and then they discuss the terms along with the employee of the lender, and that they understand those terms. So those are the kind of the real big changes that Freddie announced.
Gotcha. So does the criteria change depend on the controlling law of the state?
Yeah, it really does. And I think that's the big aspect of this that's really changed, is that Freddie's new requirements essentially break the states down in kind of two buckets: the states that do require acceptance of a legally valid POA and states that don't. So if you look at a state, let's say like Texas under the state code, like 75.1.201 requires or allows for about 10 days upon presentment of the legally valid POA to then request, an acknowledgement from the agent or an opinion letter stating that the POA is still in effect to their knowledge and it hasn't been revoked and they have the power to borrow a mortgage, essentially things like that. At which point, the lender is required to accept the POA. The thing about the state laws is, that for this is there's not really any blanket. While there are Uniform Power of Attorney Act, there are not any real blanket required acceptance of these POAs. Rather, it really kind of varies from state to state. Some states require that they use the statutory form even, and some just require it of any POA. But usually there's some additional step involved. However, say you're in a state like Kansas or Illinois where they don't have any statute requiring acceptance of that POA, then you're kind of in that more narrow requirement structure of it needing to be a medical emergency or hardship where you're unable to sign those documents electronically.
So is a letter of explanation needed whenever a POA is used, regardless of the state?
Yeah, and I'm glad you touched on that because it will be required. The updated requirements from Freddie kind of tackle them a little bit differently, or they use different verbiage on it. But essentially, it's going to be a letter of explanation from regardless of the state, kind of explaining the circumstances, whether that be, from a state that doesn't have required acceptance of a POA, where the letter will need to kind of detail the actual emergency or hardship and why they'll be unable to sign those documents electronically and why the POA is needed versus, say, a required acceptance state where you would probably mention that make a reference to the statute or a reference that is required under the state law to accept the POA and then kind of detail why you're going to be unable to attend the closing. But I think in either situation, you're going to use a letter of explanation.
Okay. Ty, can you tell us what would be a sufficient emergency situation?
Yeah, really, that's kind of a case-by-case basis. It's going to be kind of up to the judgment of the lender. I think a good example of this is incapacity. Say you have a person who is incapacitated and they have a POA. Obviously, they'll be unable to sign any documents electronically or not. That's certainly a hardship. But for most other circumstances, I think the best practice would be to reach out to Freddie Mac and kind of go over the situation with them and see if they find that to be sufficient. I know that Freddie Mac has some resources for lenders to contact them. I believe it's like a business-to-business hotline that they can call, and maybe they'll be able to shed more light on exactly what's acceptable.
Well, this has been very useful. Is there anything else that you would like to mention?
Thanks. Let me go back and kind of reiterate that that lack of a personal relationship now, where you're no longer able to appoint your friend to serve as the attorney in fact, because I know that's the one that everyone has really been used to, and that will no longer be an option under Freddie Mac. It needs to basically be, a family member, personal attorney, or an employee of the title company if the title company will issue the closing protection letter.
Well, Ty, thank you for sharing your time and expertise with us.
Well, thanks for having me. It's been great.
If you want to learn more about the subject or subscribe to the Mortgage Law Minutes, the information will be at the end of this video. Thank you for watching, and we'll see you again soon.
Thank you.